Good afternoon, all the esteemed members of our profession. Our beloved C.S. Devendra Deshpande, President of our institute. C.S. Manish Gupta.
Sir, we have yet to go live, sir. Mr. Makhija hasn't yet joined. We have yet to go live.
Okay, so please let us know once it is live.
Yeah, sure. I'll let you know.
Okay. Stop karo. Good afternoon to all my esteemed members and students of our profession. I welcome you all to the webinar series, and the first being Inquiry Proceeding Awareness for Company Secretaries. I welcome C.S. Devendra Deshpande, our beloved President of Institute, C.S. Manish Gupta, Vice President of our Institute, esteemed speakers who are lined up for today, most revered Sri T.J. Krishna Bhatta, IPS retired, Sri Diljit Singh Ahluwalia ji, who is an advocate, and along with him Sri Ashish Makhija ji, advocate, who is going to speak on the topic on the inquiry proceedings and especially awareness for company secretaries. Friends, as known to you all, the main object of the Company Secretaries Act is development and regulation of profession of company secretaries. The moment we talk about regulation is by virtue of various mechanism which includes the Board of Discipline as well as by the Disciplinary Directorate. Above all, of late we have seen that the standards, the bar has to be increased by all the professionals, and in that arena, career awareness as well as inquiry awareness is required so far as the members of our profession as well as the student is concerned. And I compliment our president, I compliment our vice president in having this noble topic of inquiry proceedings so that it can help all our members, especially the young professional who have joined our profession and especially those who are in practice as well, as to how to face an inquiry, as to how to face when somebody knocks your door and asks for certain things which may not be comfortable for the professional, whether it is in case of a CBI, in case of police, or in case of a DC matter, or in case of various show cause notices which are issued. At the end of the day, let us all as a professional, we have to set our own standard, we have to set our own bar. And in that connection, we are having this inquiry proceedings for the awareness of the company secretaries. I would now first request our Manish Gupta ji, Vice President of our institute, to kindly share his thought and vision in connection with our institute first, please. Manish Gupta, over to you.
Thank you, Nagendra ji. President ICSI, Devendra Deshpande. Immediate past President ICSI, Nagendra D. Rao ji. Distinguished guests and speakers for today's webinar. Shri T.G. Krishna Bhattaji, retired IPS, Advocate Shri Diljit Singh Ji, Ahluwalia, and Advocate Shri Ashish Makhija Ji, other professionals and students who have joined this program. Very good afternoon to each one of you. At the outset, I would like to welcome you all to this webinar. Friends, today's webinar is on the theme of inquiry proceedings to be managed by the members of the institute in case they have been issued with the notice of show cause notices by any of the regulators, or in case an FIR is being lodged against those members, or in case the disciplinary proceedings are being initiated against any of those members of the institute. We as company secretaries are always treated as the watchdogs of the corporate governance, and utmost care is expected from the company secretaries while discharging their duties, irrespective of the fact whether we are in the job or we are in our own practice. We as professionals have been contributing immensely to we have been towards the purpose. Have been guiding and assisting their clients in complying with various statutory provisions which are being enacted by the governments. It is important for us as professionals to be aware about the legal framework we have to work and be aware of the implications. In the recent past, we have seen many searches where our company secretaries were made party to the proceedings being initiated, either by the regulators, any of those regulators, I would say. It may be ED, Sfio, RD, SBI, NCLT have also issued various summons to our company secretaries in the proceedings against the directors and KMPs of the companies. We have also seen many cases where practicing company secretaries or the employee company secretaries is also made party in the matters of the internal dispute between the directors, in the matters of the operation and management. It has also been observed in many of the cases, professionals have acted without any relevant intention, our company secretaries particularly. But still, the show cause were issued, the summons were issued, arrest warrants were also issued under the suspension, and without any solid grounds and background about it. This creates lots of sense of fear and anxiety among the entire professional community. Friends, I was also part of the board of discipline for last 3 years, and I had witnessed that out of 10 cases which were filed in the disciplinary, more than 4 or 5 cases were related to the internal dispute between the management. But our company secretaries were also made parties to all those proceedings for either for certifying the forms or for non-cooperation from the management. Now the time has come when we all have to deal with these situations more practically, more professionally. At ICSI, we had thought it fit to have this program under the awareness series, wherein our endeavor is to provide the handholding and the support to all of our members so that they can deal with any of those situations and inquiry proceedings more effectively and more efficiently. Friends, the first and foremost advice from my side is whenever you got any such show cause or any inquiry proceedings notice, it is not to panic whenever you are getting any such notice, and be calm and be on your foot. Try to have discussions with the seniors, try to resolve the thing amicably before pushing it hard, and try to resolve the things in hasty manner. Friends, time is always an essence of show cause notices. We have seen in the past that professionals sometimes avoid or linger on while responding back to those show cause notices and the proceeding being started. My humble request to each one of you, whenever there is a notice, you please revert back, reply back, all those attachments and annexes within the specified time framework. Please don't linger in or don't avoid any such revert. Friends, today we are fortunate enough that we have with us Shri T.G. Krishna Bhattaji, retired IPS. We welcome you, sir, in this occasion, and I'm thankful to you for accepting our request and this invitation. We also have the Ahluwalia ji and Ashish Makhija ji would also be joining in a few minutes. And friends, today all the distinguished guests are going to share their practical experience with any of those situations. And what would be the intricacies, disciplinary cases, and how to respond back to those notices which are being issued to the members. I am sure today's deliberation would certainly help our members and would be of immense value and extremely beneficial for the profession for equipping themselves to deal with various legal proceedings and actions. And I am sure that our members would serve the expectations of stakeholders. Welcome you all once again to this webinar. Thank you very much. Thanks a lot.
Thank you very much, Manish ji, for your enlightening words. I now request C.S. Devendra Deshpande, our beloved president of our institute, to kindly share his word of wisdom, please. Over to you, sir, please.
Thank you, Nagendra ji. My warm regards to the faculties today, T.G. Krishna Bhatta ji, for accepting our invitation, Advocate Diljit Singh Ahluwalia ji and Ashish Makhija ji. Let me tell you, friends, that we were discussing about this particular topic for last 1 week. And when me, Manish and Nagendra ji, we were discussing, Nagendra ji said, okay, this is a very good topic and I would moderate this particular session because I want members to know, understand what are the perspective of regulator. So he requested T.G. Krishna Bhatta ji to speak to our members so that he can tell us that what is the perspective of a regulator when he sends some notice, when he sends some, when the FIR is filed, then what is his perspective when he looks at a professional? Because as company secretaries, we deal with non-financial matters. And if we look at our institute's overall framework, we do have a robust system of discipline. We do have due diligence which is required to be done, and we always keep on mentioning this or propagating this, that whenever there is a new customer, you should go for KYC, you should go for a proper due diligence. Whenever you are certifying, there are few limited benchmarks which you should go through. And now we have also come out with the peer review system, wherein a company secretary can provide certain services only if he is peer reviewed. So the processes are set in the practicing professionals office. So this is a viewpoint of the institute, that our members are equipped, our members deal with non-financial cases, and generally financial frauds and all those cases are not dealt by our members. But in spite of this, sometimes the member gets caught in the management dispute many of the times, wherein he certifies certain documents or on the basis of certain documents which he goes through, that may not be a sufficient due diligence. In that case, he gets caught. KYC is not done properly. So if you are doing a work through somebody, some other professional, and you end up doing some wrong certification, and then this entire legal cases do start, then this inquiry start, and then you have to face this. So all the members might be doing it in very fair and good manner, but sometimes due to some failure or some small mistake, you end up in getting the notices, getting the summons, getting the various FIRs registered against you. Might be out of the management dispute, or it might be because of a small mistake from your side. So if these things happen, then what should be done? So then we invited the Advocate Diljit Singh Ahluwalia. So the first thing is perspective of the regulator, how they feel that professionals are involved. Then there is advocate who would actually tell us that how to handle if such notices are received and how the legal process takes place. And then we do have Ashish Makhija ji, who would take care about the matters. There will be 2-3 cases simultaneously going on against a professional if there is a bigger management dispute or some mistake has happened. The one would be at the court case, one may be at various regulatory authorities like ED, Sfio, as rightly pointed out by Manish ji, our Vice President. And third one would be at the institute, wherein the disciplinary mechanism is a robust, we do have a robust mechanism. So in that also people will put you the case. So all these things will be discussed today. And that was the main purpose of having this particular webinar, so that we inform all our members that first, you don't make any mistake. If there is a mistake or there is something which has happened, then how to face it. So we have to be ready that in the tough situations, because the COVID is in and out, and the management disputes are really going on in a very high number. So I think in such a situation, our members should be prepared. Even if there is a legal case, even if there is an inquiry against them, they should be prepared. So that is the main purpose of this particular webinar. In addition to that, let me tell you, friends, that this is all about today's webinar, but 2-3 announcements which I would like to share with our members. The first thing is the Ministry of Corporate Affairs is coming out with third version of its website, and it is going to get launched on 6th of March for the LLPs. So Institute is organizing 3 or 4 webinars to inform our members about the technicalities of the new website and how to handle this, along with the officials of Ministry of Corporate Affairs. So you all are requested to attend that particular webinar so that we are well versed with the new system. We are also going to go ahead and bring one Google form, wherein after 6 March you might be having some technical issues which will be solved through a committee, official committee constituted by our institute to resolve the problems faced by the members while working with the new system. So these webinars and this Google form can be used by our members for smooth conversion from version 2 to version 3. So I request all the members to take advantage of this particular thing. And on 23rd of March, we are having our first international conference at Dubai. So the Block Your Diary flyer has already been sent to all the members, and soon in a couple of days time we will be sharing the details of that particular international conference. So those who are interested in attending, they can also attend that particular webinar. And we are coming out with various webinars and various programs. The calendar is already rolled out at one of the leadership summit program, which is wherein all the chairmen of chapter and regions came together, and they have actually planned the entire year for the benefit of members and students. So I think these are the few things which I wanted to share with all the members. And thank you very much, Nagendra ji, for moderating this, and I am sure that you will take it forward in a wonderful manner, and all the faculties, people are eager to listen to all our faculties. So over to you, Nagendra ji. Thank you very much, and I hope everybody would enjoy this particular. Thank you.
Thank you. Thank you very much, C.S. Devendra Deshpande, our beloved president, for highlighting the various nuances which is required, and all our professional has to be on the toes, as well as updating the future about the new initiatives which have been taken by the institute. Friends, now we are all awaiting for the much awaited program with regards to the inquiry proceedings. Now, before I request Sri T.G. Krishna Bhatta, the retired IPS officer, I would briefly introduce sir, and then I would request him to take over. Sir is a BA from Delhi University, MA in Economics from Rajasthan University, Jaipur. Sir has served from Indian Air Force from the year 1976 to 1983. Sir was lecturer in Economics, Government Junior College in Chikmagaluru district from 1984 to 1985. He was Inspector of Income Tax, Bangalore in the year 1985 and 86. From November 1986 onwards, he is in the police department as a Deputy Superintendent of Bagalkot from Jamkhandi, Additional SP of Gulbarga, Belgavi and Chikmagalur, SP of Chikballapura, Ramnagara, DSCP Intelligence, DCP South Division, DCP Administration and DCP East Division, Bangalore City, DIG Intelligence, Bangalore, Commissioner of Police, Belgavi, from July 2016 to November 2017, and above all, he is the recipient of the President Police Medal for the meritorious service in 2010. Sir, we once again welcome you to this webinar. We are really elated to hear you. We request you to kindly address our members, please. Over to you, sir, please.
Thank you again, Raji. Good afternoon, everybody. Respected Devendra V. Deshpande, President ICSI, the past president, immediate past president and Vice President CSI, Shri C.S. Nagendra D. Rao, Manish Gupta ji, Vice President ICSC, today's distinguished speakers from legal fraternity, Shri Diljit Singh Ahluwalia ji, Shri Ashish Makhija ji, office bearers of ICSI, and all participants of this webinar. At the very outset, I would like to express my sincere thanks to the office bearers of Institute of Company Secretaries of India for inviting me to take part in this webinar and address the points regarding police department's perspective towards legal action on professionals. I have been informed by the organizers to make beginners, freshers, or students or probationers, if there are, aware of facing inquiry proceedings. This is the brief I have been given. Before coming to the central topic, this topic of today's webinar, I feel it necessary to dwell upon certain acts and provisions of law, especially with respect to police department. This would help in better understanding and appreciating the role of police in criminal justice system. There are numerous central acts and state acts called special laws and local laws. But for the police, 3 substantive criminal major laws are most important. They are the Indian Penal Code, the Criminal Procedure Code, and the Evidence Act. All these have been framed by British. Our our distinguished speakers from legal fraternity, they know very well how it is difficult to change even a single word or a sentence or a passage in some of the acts. It is so well worded. It was found with British, and we have continued it. Here and there have been some criminal amendment act to these Indian Penal Code and Criminal Procedure Code, also Evidence Act, but we have not been in a position to change it altogether. First of all, the Indian Penal Code, which has 23 chapters with 511 sections, is the substantive criminal law of the land, which defines offences and punishments. Chapter 2, pertaining to general explanations, in which there is an important section. So I would like to draw the attention of all the students and all the professionals of this company secretaries. This is an important section that comes to your rescue every time. That is called good faith. Whatever is done in good faith, you get the protection. So the definition of this good faith is given in section 52 of Indian Penal Code. Chapter 4 lists out general explanations, general exceptions. For police, most important chapters are Chapter 5, that is regarding abatement, 5A, criminal conspiracy, Chapter 8, offences against public tranquility, Chapter 11, false evidence and offences against public justice, Chapter 16, offences affecting human body, Chapter 17, offences against property, Chapter 18, relating to documents and property, Chapter 19, criminal breach of trust. These are some more are there that we usually handle in a routine way, but these are the most important chapters. And most of the offences which regularly are handled by police are covered under this. But police have power to investigate any case under any law, and any section of the law says an offence is cognizable. whenever cognizable offense is there, police get the power of investigation. Next, coming to the CRPC, section 2 is the most important section. It's called definition section. All the legal, most of the legal terminologies used in criminal law, like, cognizable case, non-cognizable case, what is a complaint, and what are the categories of courts, then what is inquiry, what is investigation, what is the jurisdiction, what does judicial proceeding mean, and what is a police station, who is the officer in charge of police station, what is police report, and prosecutors. How they are also, there is a very detailed definition regarding what type of prosecutors are there. Then what is a summons case, what is a warrant case, etc. In fact, the definition of, as per the definition of CRPC, inquiry means any inquiry other than a trial conducted under Criminal Procedure Code by a magistrate or court. And investigation includes all the proceedings under the CRPC for the collection of evidence by a police officer. Here I would like to take a small digression. Since the webinar topic is inquiry proceedings, normally inquiry proceedings refers to, if you Google also you will find that it refers to departmental proceedings. Departmental proceedings are quasi-judicial proceedings. Usually that is held by various departments, because all departments have framed law, disciplinary proceeding rules under the law only, and any misconduct or any violation, any transgression of this disciplinary rules, it is dealt with departmentally. So in that, normally a preliminary inquiry is held. Based on the preliminary inquiry, the disciplinary authority, there are different type of authorities, appointing authority and disciplinary authority, but here disciplining authority, in the disciplinary authority, he appoints one inquiry officer, assisted by one presenting officer. Then when this starts, it is as good as a court proceeding. Usually on the prosecution side, that is the government side, whereas here presenting officer presents the facts of the case and against the servant. He may be accused, he is a government servant. Usually in police department we call it APO, the accused police officer. Otherwise in departmental inquiry he is called accused government servant. It may be similar, minor modifications may apply to other departments also. Then he has to defend himself. For that he has to engage with defense counsel. And proceedings are like that only in as good as in a court of law, like prosecution. That is first is examination in chief, then the defense is allowed to cross-examine. If necessary, re-examination may be there. Documents are presented and they are exhibited and marked. They are marked and made as exhibits. On this only it is relied. Once this is done, the accused government servant or accused police officer's statement is taken. Minutes are drawn by the inquiry officer. He sends it to the disciplinary authority. Disciplinary authority then takes his decision based on the evidence collected during the course of inquiry. Then usually what he does is, there are three types of penalties. There is a fundamental difference between a punishment and a penalty. He imposes penalty. The disciplinary authority is authorized to impose three types of penalties. There is major penalty, minor penalty, and summary disposals. That is usually departmental inquiries. As far as police are concerned, what police do, it is investigation. Investigation is something different from this type of inquiry. So, next comes chapter 4 of Criminal Procedure Code that talks about the power of superior police officers. Chapter 5 is about arrest of persons. Chapter 8, it is regarding obtaining security for keeping peace and good behavior by, as you know, rowdies, gundas, etc. This is usually done by the executive magistrate, not the judicial magistrate. Most important is chapter 12 for police officers, which deals with information to police and their power to investigate. It starts from section 154, ends with section 176. Under this particular chapter only, most of the police investigation is done. Chapter 154 is, section 154 of this particular chapter 12, that is about FIR. Whenever any information regarding commission of a cognizable offense comes to the police station or the police officer, he is supposed to go through it and prepare and issue FIR. He is supposed to give a copy of the FIR to the complainant. FIR goes to the jurisdiction magistrate. Immediately he has to make those entries in the diary, station house diary, and immediately he has to proceed to the spot depending upon the nature of the case. Then he has to proceed with the investigation. I'll come a bit later. Then section 155 is regarding non-cognizable offences. A non-cognizable offence is an offence in which police have no power of arrest directly. He has to make a report to the jurisdictional magistrate. If it is to be investigated, he has to request the magistrate. If magistrate feels it necessary, he may order investigation. Then he gets all the powers under this. Then comes section 156. There is police officers' power to investigate. That is cognizable offences. There is one more section. Whereas honorable speakers, president, vice president, they were telling about professionals receiving summons from police like that. Police are not supposed to. Will be summoning. That we are not competent or authorized to issue summons. What police do is under 160 of CRPC, they have power to require the attendance of any witness. So they issue notice. It is a notice under 160 CRPC. And if that person comes there, and if some statement has to be taken, it is taken under section 161 of CRPC. Then comes, if at all a person who deposes before the police is likely to go hostile at the time of trial, then normally police take that witness, if he is an important witness, very material witness, then he is taken to the jurisdictional magistrate, requesting the magistrate to take his confessional statement in respect of accused, and his statement is recorded. Police request the magistrate to record his statement. So if a statement is recorded by the magistrate, it has more credence, more value. Even if it goes hostile and he deposes before the magistrate, so usually magistrate takes those statements under oath. So it has more credibility, it has more value also. Then 165 CRPC talks about search and seizure powers of police. Section 170, 172. So this pertains to the preparation of final report. There are three kinds of report. If police, after getting sufficient evidence, if they charge sheet the case, it is called A report. If no sufficient evidence is not coming, or patently false, or maybe civil dispute, they file a B report. If case is mostly in respect of property, usually it is called C report, undetected. Police are not in a position to detect whether who has done the offence, when it was done, all those things conclusively. If they are unable to find it out, they submit C report. And as far as the new Indian Evidence Act is concerned, only one important section in the Evidence Act is very useful to police, very widely, very extensively used, is Section 27 of Indian Evidence Act. That is about especially criminal cases, especially confession statement by an accused while in police custody. That confession statement, if it leads to, in the statement, some facts lead to the recovery of the property related to the offence. Because upon this only, most of the police cases, police are in a position to secure conviction. Otherwise, if it was not there, it would have been very difficult for police. Friends, with this background, I will come back to the main topic now. That is police department perspective concerning legal action on professionals. Anyway, again, it is sort of repetition. Whenever a cognizable case is reported to the police at the police station, FIR has to be prepared, as I told earlier. So it goes to jurisdictional magistrate. So police have to immediately, of course, in respect of grave crimes, they should visit the spot, draft spot panchanama in the presence of two respectable inhabitants. This is the condition, what we have got from British, two respectable inhabitants. But in my personal experience, I have seen, no, including me or you, if something happens in my vicinity, if police call and ask me to be a pancha, will we ever do it? No. Not that we shouldn't, but because of our hassles, not many, people are put to a lot of problem also because of this. That's why everybody avoids that. But so law has to take its own course. For that, everybody have to support. Knowingly or unknowingly, we may not like it, but this is the necessity of the law. That's why I'm telling this. Our legal fraternity brothers, they can elaborate it further, because police are in the habit of hoisting witness called as stock witnesses. Panchas as called stock panchas, because no one else is coming. So they get hold of somebody, get the signature on Panchanama, and produce them as panchas before the court at the time of trial. But that naturally is a disaster actually. It ends in acquittal. Most of the cases, it's like acquittal of the case only happens. Thereafter, recording of the evidence has to be done. Nowadays, electronic, since electronic media is also being used, usually statements are videographed and voice is recorded, because most of the times witnesses, although they give evidence to police, they go hostile at the time of trial. Also, eyewitness and other witness evidence is taken. If document is to be collected, that has to be collected. Again, for everything, Panchanama has to be drawn. Depending on the case, document evidence are usually collected. Not in all cases. Then case diaries have to be written. And after getting some sufficient evidence, police usually discuss with prosecutors, because these cases have to be handled by the prosecutors during trial. For that, usually in every district, every commissionerate, there are assistant director of prosecution or deputy director of prosecution in consultation with them. If anything has to be altered, modified, anything or some more investigation has to be done, those things are done, and a report is prepared. As I mentioned earlier, it may be A report if it's getting charge sheeted, otherwise B report or C report, like that. So all these things are the duty of police. And once it goes to court for further proceedings, is for the court to fix up the date for hearing and all those things. That is left to the judiciary. Police officers are duty bound to conduct investigation in a fair and impartial manner. That is the expectation of everybody. We agree. But the way sometimes some of the police officers or investigating officers, their approach may be sometimes harsh or something. It may appear so. But every effort is being taken within the department, right from their training days to regarding human rights, and especially how to go, how to communicate with different category of people. So they are given that input also. Then ultimately, when it comes to the practical things, it depends upon the individual. There may be some aberrations. So I wish to reiterate that this, in a perspective of the police department, is to bring the offender to book by following due course of law. That is the perspective. In the dispensation of justice, many wings are there. Most important is the judiciary. For them to conduct their proceedings, police have to be there, prosecution has to be there, and regarding documents, experts have to be there, and so many other contributors have to be there to meet the ends of the goal of criminal justice. As far as company secretaries are concerned, you are all professionals doing your duty in the specified field. And once if you receive some summons from court you directly, normally you don't receive summons unless the court has taken cognizance of the case and is going ahead on its own without depending upon any police report. You may. Otherwise, from police side, you will receive a notice under section 160. That is police notice. And you do not get panic. So, they need not worry. While certifying an entity for incorporation, you would have very cautiously verified all the documents given by those people, like Aadhaar card, PAN card, or bank account, mobile number, email is usually taken nowadays, MOA, AOA, so many things are there. And other, whatever is possible, you would have done it. That's why in the beginning I told good faith. So you have done all these things in good faith. Once you have done in good faith, if something may, if something happens, that will not definitely affect you. That good faith is going to protect you. Only thing that you have not with malified intention, or malified intention, you have not colluded with the party and you have given this certification. Only thing that is required for the police. And regarding the authenticity of documents, only after due verification, you would have certified them. So if a police officer comes you can definitely tell. These are the points based on which I went through this, and it was sufficient in the as far as starting of a company or corporation or a partnership or whatever may be the business. So in good faith, I have done this and I have certified. There's nothing wrong in telling that. And police, honestly, they do not find fault with this. Only thing people may get, initially bit terrified was police comes in, because police is such an allergy or anathema right from British days, not today, and it is going to stay for some more time unless the people get the right view on this regard. So you are protected, you not worry about it. The police, once they issue notice, they usually call for your recording of your statement to a place. Then please go there with the records. Please go there, show the records. These are the records based on which I was satisfied, and it was sufficient for the purpose of certification. I have certified it. There is nothing wrong in it, and police won't go further. Naturally, they will record the statement, because please keep it in mind. If a case is booked, it is not against you. If the case is against somebody, you are a witness. The documents which he has given to you may be fraudulently obtained, illegally obtained. All those things are one more piece of evidence, and you are only a witness. You are not going to be, as far as possible, unless modified intention is there. Everything is, if it is, it comes on record, then only you will be hauled up. Otherwise, for most part of the thing, you need not worry at all. You can show your innocence, or by good faith is the thing, bona fide intention you have done this. So this is the advice for all the professionals I wish to tell. They need not worry about others. And as far as police approach, regarding this, as I have mentioned earlier, in police also, frequently some courses are conducted and some meetings are held. Everywhere police are told to be polite but firm. Their intention is to collect as much document as possible, because any guilt has to be proved to the hilt. So there should be no room for suspicion. So that's why police put all those efforts. Please understand the role of police, because they have nothing personal in this. They are doing a public duty to meet the ends of justice. They are a part of this. So probably I have taken, if I have maybe exceeded some more time. I thank once more the organizers, everybody of this, ICSE. I am open to any doubts, I can, within my limited knowledge, I will try to answer those things. With these words, I end my speech. Thank you so much. Thank you.
Thank you so much, Krishna Bhattavare, for enlightening us, and especially from guilt to hilt and from polite to firmness. When we also professional appear before the police authority, I am sure that all our learned professional will show the good faith, section 52, about the general exception and all those due diligence what they have done while certifying the various documents forms. So all our professional, I know, since they would have done very good due diligence, they need not have to worry, but they should not be complacent. They should do their homework very well. Sir, before I move on to other speaker, one small question to you, sir. Sir, you were DIG Intelligence. Whether professionals are also included for the intelligence when, or you are just looking into the law and order situation, whether corporates are also covered or whether professionals are covered, who and all are normally covered in intelligence?
See, for that matter, intelligence, it is a very difficult subject to define, because everything under the sun comes under intelligence. Anyway, but priority of the intelligence is the security and integrity of the nation, and the safety and public order. The factors which are at work, at disturbing the peace and order of the society, of the nation, of the state, or maybe a particular. So on those elements, intelligence people keep watch. They gather regular information. Maybe, for example, Naxalites, they are held up somewhere, but they have got supporters in various forums and also in cities also. So on everybody we have to gather in intelligence those information and provide those information to the people. It should be an actionable intelligence. So we have to provide that information to those people who can take some action. That is the thing. But top priority is as I've told, it should be our peace and order. The law and order has to be maintained. There should be no disturbance as far as governance is concerned. It is directly under the chief minister. Intelligence wing is usually under the chief minister directly. So intelligence head briefs every morning the chief minister of the state. So he to bring to the knowledge of the chief minister. But of late, as you all know, priorities change. But as long as I was there as DIG intelligence, my priority was on these matters. See, there are different groups are there, like rice, farmers. They have got their own problems. They may be holding agitation somewhere. There are students. During my day, student problem was not there. There may be labor class. See, usually labor unions are there. Sometimes they may stage big protests like that. As I told you earlier, there are some people now they are staying here but working for someone else. On those people we have to keep watch. And different political groups will be, different language groups will be. So in the under intelligence, everything under sun comes. I think this would be sufficient.
Thank you so much, sir. We now move ahead with Shri Diljit Singh Ahluwalia ji. Before I request Shri Diljit Singh Ahluwalia ji, let me just briefly read his profile. Shri Diljit Singh Ahluwalia ji is an advocate, Supreme Court of India, and is a proprietor of Ahluwalia Law Practice. He has a rich experience as a lead counsel in eminent criminal cases with exposure abroad, pioneer in formulating legal cover for senior management of corporates, high net worth individuals, politicians, celebrities. His core expertise is in criminal and constitutional law, formulation of litigative strategy in India and abroad, formulation of legal strategy for criminal investigation, including preliminary inquiry, investigation by the CBI, Enforcement Directorate, Directorate of Revenue Intelligence, Sfio, and Police, providing prophylactic criminal civil liability cover to corporates as well as individuals, and his professional ethos is in pursuit of excellence, is an attitude. The major cases, I would like to read out a few of them. Gali Janardhan Reddy, MD, Obulapuram Mining Company, MRMGF, YS Jagan Mohan Reddy, Vijay Sai Reddy, YSR Congress at Hyderabad, Sukesh Gupta, and many other celebrity cases are innumerable. Sir, we welcome you. I request you to kindly address our members, please. Over to you, Ahluwalia ji.
Thank you. Respected fellow speakers, office bearers of the ICS and participants. So I'm going to be covering my talk in 4 heads. First is going to be the introduction. Second will be how does criminal law play out in India. Third is going to be how can the corporates and the company secretaries protect themselves. And fourth, I'm going to be sharing some experiences and takeaway points. First, coming on to the introduction. The level of civilization can be gauged of any country in the manner they enforce the criminal law. In United States of America, the procedural safeguards are rigorously enforced. Trials are fast. Abuse of criminal law has got huge consequences on the civil side. On the other hand, in India, criminal law often degenerates into an instrument of harassment and extortion. Often it is a lifelong battle. Delay defeats the ends of justice. Suspicion by the media is often seen to be overriding proof of guilt. Now, as far as criminal justice dispensation is concerned, it is something like oxygen in the air. People do not care or know about it much till the time it is withdrawn. How does criminal law play out in India? That's the second head of my interaction with you today. Firstly, it has already been brought out as to what is investigation. Now, investigation is a process of collection of evidence. that is investigation. What are cognizable offenses? Cognizable offenses are those offenses in which the police can arrest anybody without getting any warrant from the magistrate. Coming on straight away to notices. Now I'll be dealing with two kinds of notices. One is a notice under 160. That is a notice which is given by the police to the witnesses. Then there is a notice under 41A of the CRPC, which is the one which is given to the accused persons. And third kind of notice is under 91 CRPC, which is essentially to get the document that can be issued by the SHO. It can also be issued by the court. Having given a prelude to this, the start point of criminal law is under section 154 of the CRPC, which is registration of FIR. FIR is first information report. When the first report is given to the police officers of commission of cognizable offences, they are duty bound under law to register the FIR. But often we have seen that registration of FIR till today remains the number one cause of police corruption in the country. In spite of the Honorable Supreme Court of India having come out with a constitutional bench judgment in state of Uttar Pradesh versus Lalita Kumari, wherein they have said that when an information is provided which discloses commission of cognizable offences, FIR will be registered, and if it is not registered, then action will be taken against the delinquent officials. Any person can walk into a police station and see whether his FIR can be registered even till date, in spite of such categorical directions by the Honorable Supreme Court of India. So number one, the biggest task is getting an FIR registered. Now that is under 154. Let us say that the police does not register the FIR, then one can give the gist of the information to the senior officers of police, that's the superintendent of police, under 154(3), who after reading the information or the complaint, if he feels that cognizable offences are made out, then he can enable direct registration of FIR. Then there are those non-cognizable offences, which is the category wherein the police officers don't have the power of investigation, they don't have the power of arrest, wherein the police officers make an entry and thereafter direct a person to go to the magistrate, and you go to the magistrate, obtain orders from the magistrate. Thereafter, FIR can be registered and they can carry out investigation, but without the power of arrest. Section 156(3) is the one which deals with the powers of the police to investigate cognizable offences. Now, if they don't register the FIR, then under 156(3) of the CRPC, any informant can approach the court seeking directions to the police to register the FIR and carry out investigation. Often we have seen that normally the courts tend to take cognizance of the offences, and there starts the procedure of complaint case. So this is in brief, starting the criminal law into motion is the FIR. Another aspect of police practice is that without registration of FIR, at the stage of inquiry, they tend to carry out investigation and then they say, there is no offence which is made out, so we are not registering the FIR. Now the difficulty is that even though Lalita Kumari has been passed by a constitution bench, but we have seen often that when we approach the court again, that well, FIR is not being registered, somehow there is a lack of determination even as far as the judiciary is concerned to enforce Lalita Kumari. Either it should be there or should not be there. Lalita Kumari says it has to be registered, yet when it is not registered, you try and approach anybody to take action against the police officers, no action is taken. So this is the grey area of law as far as registration of the FIR is concerned. Once the FIR is registered, even then, most of the police officers at the level of SHOs don't know that they still have a power not to investigate. That is under 157 of the CRPC. If they feel that there are no grounds to carry out the investigation, they can just stop the investigation, inform the magistrate and the informant that we are not carrying out investigation. And thereafter, it is up to the magistrate to carry out inquiry or direct them to carry out investigation. Next, we come on to 160, which is a provision wherein the police officers can summon the witnesses. That is the notice which is given. Once we as company secretaries are called under, let's say, a notice under 160 of CRPC. Our statement is recorded under 161 CRPC. No statement has to be signed by any witness. That is as per 162 of the CRPC. Yet, as a matter of practice, the police officers, IOs, make a person sign every statement which is against the law. I'm sorry, my anguish is going to be, being a criminal lawyer, this is something which I face all the time, and we lament before the court, but at times these things are not taken very seriously. But these have got very serious ramifications. Now, another thing which the company secretary should know is that a notice comes under 160 CRPC, which is basically a notice to a witness. And you happily walk into the police station saying, oh, I have just been called as a witness. The moment you land up there as a witness, they record your statement, make you sit throughout the day, and towards the end of the day, they arrest you. They say, well, during the course of your statement, we have got to know that you are also involved with the crime, so we are taking you into custody. So see, you are called as a witness, your statement is given as a witness, which a witness can give you anything, but as an accused, I have a right that I cannot be forced to self-incriminate myself. So calling you as a witness and taking your statement and thereafter converting your hat to that of an accused, this is also something which is a matter of common practice, especially in CBI cases, wherein you come as a 160, a witness, and thereafter you don the hat of a accused person. Thereafter, let's come on to 164. 164, like my learned friend has already brought out, it is basically a statement which is recorded before a magistrate. It is under oath. Once that is recorded at the stage of investigation, that has got a lot of evidentiary value, although as far as trial is concerned, there is not much of difference between 161 and 164. But at that stage of investigation, the police officers always tom-tom before the court, we have a 164 statement. 173 is the final report which is filed by the police officers. Now, it can be a closure report wherein they find that there is no cognizable offense made out, there is no material in support, or it can be a final report in the form of a charge sheet. The power of the police to carry out further investigation is codified under 173 subsection 8, wherein if on receipt of further information they feel that further investigation is required, they can inform the magistrate and carry out further investigation. However, as a matter of abuse of criminal law, it has been seen that especially the CBI, and as you would have seen in the case of Mr. Jagan Mohan Reddy, where there were 13 charge sheets which were filed. 13 separate FIRs, all emanating from the same cause of action, because they wanted to keep him in custody. First FIR, second FIR, third FIR, fourth FIR, then you file one charge sheet and tell the court we want to carry out further investigation. The moment you apply for bail, we are carrying out further investigation, they file supplementary charge sheet. So these are all the grey areas of law which are basically abused by the police authorities. Now, having come to the end of the investigation, I will get back to the beginning of the investigation, wherein the police officers have the power to carry out preliminary investigation or preliminary inquiry. Now, that has been codified by the Supreme Court in the same judgment on Lalita Kumari, wherein they say that for a certain category of cases, you can carry out preliminary inquiry. Now, preliminary inquiry is not investigation. It is basically to read the complaint and to find out whether cognizable offenses are made out or not. If they are made out, FIR has to be registered. But under the garb of preliminary inquiry, the police officers carry out the entire investigation. And there was a case in Gurgaon, without taking names, a very senior police officer filed objections before the lower court saying, at the stage of inquiry, I want him for custodial interrogation because I am carrying out investigation. And surprisingly, in Gurgaon and Haryana and at times in Punjab, when FIRs are registered, the FIRs also speak of after investigation, offenses were found to be committed and hence the FIR is being registered. So, I mean, this was just to give you a preview as to how criminal law is set into motion. Now, let me quickly come on to what all are your rights if you were to get a notice. Let's say there is a notice under 160. Company secretaries are basically nothing but an armor plating for the management. They, in the contract of employment, so many hidden things are given in that. You will be responsible for this, you will be responsible for that. And the poor guy gets caught up in the investigation. The management people run away to UK and to USA leaving the poor company secretary facing the investigation by the CBI, ED, DRI, all these people. Now, the moment you get a notice under even 160, please rush immediately to a lawyer and consult him at that stage, because it might be something wherein you might have a reasonable apprehension of arrest, because naturally when the entire management has run away and you are the only sacrificial lamb who's there, they will arrest you. Like I've told you, they will call you as a witness, convert you as an accused and take you into custody. So kindly consult at that time. There might be a requirement of taking anticipatory bail. Anticipatory bail is that you move the district court seeking interim protection. If that is not granted, you come on to the High Court, take some kind of interim protection before you go on to face the police officers. If by chance, unfortunately, any person is taken into custody, then there are provisions with regard to bail. Now, what are the things you can do at that stage? Let's say, unfortunately, company secretaries have been, they are key management people and their names are now reflected in the FIR. So what are your rights? I've already spoken about anticipatory bail. I've talked about regular bail. If somebody is unfortunate to have got arrested, then there are two other rights that you have. One, you can challenge the FIR itself, that you have no role to play. A bare reading of the FIR does not disclose any offences. Ingredients of the offences are not there. Let's say, for example, although it's not related to company secretaries, FIR reads that A has basically taken a knife and he has threatened me with it. Right? Threat with a knife. And the FIR which registers is that of rape, that this person has committed rape. So you will immediately file a quash petition before the High Court and say that for an offence of rape, the ingredients are not paid out, so please take me out of this case. So one is that you can file a quash petition. Second is you can also go the route of writ petition, which is much wider, wherein you can talk about your violation to the fundamental rights. Another thing which perhaps not very many lawyers go that route, but those people who are practicing exclusively on the criminal side may take it as a first step of defense, is that the moment your name gets involved in an FIR, straight away register a cross FIR against the person who's the informant in the first one. Because ultimately, it is like both the scales should be balanced. If it is not balanced, that person is going to be running to the court, running after the police, carry out arrest, carry out arrest. So the moment there is a cross FIR, you give your version. I'm not saying give a false complaint or false information. I am sure that you would also have a cross version with regard to what the other person is saying. Or you might say, the boss is not me. It is the owner who's sitting in Hawaii. He's the one who's done this. These are not my signatures. Whatever be your cross version, try to bring it before the police. If they don't register an FIR, get a cross FIR registered. Let both the version and the cross version be investigated by the police. That's the best way of getting out of a criminal case. If there is any kind of an infirmity or false information, you may even want to file a perjury application. Although, let me tell you, as a matter of fact, our courts are very, very insensitive to perjury because of the society we live in. Because even as lawyers, most of the time what happens is you file something in affidavit, you are arguing something which is contrary to what you have filed before the court on affidavit. And when it is brought to the other side, they say, "Arey vakil sahab, aise mat kariye." And try this in a US court and shake like this when an affidavit is given by anybody. Try it in a British court or UK court. Not happens, because their perjury means that you will be picked up from there. You don't even have to walk. Two people will come, they'll pick you up like that only, and your legs are going to be in the air and you'll be taken to a jail cell. That is the place where you will sit till the time the perjury application is decided. Coming on to now, I will just briefly touch upon how criminal proceedings are initiated in the US. Now, this is just to give you a little bit of a flavor as to how criminal proceedings can be initiated in India at the drop of a hat. You just have to make some allegations. Those allegations have to make out a cognizable offense. And the Supreme Court says that truthfulness and falsity is a matter of, a trial, not even investigation. So when a person makes a false complaint against a company secretary, he's taking advantage of the law of India that cognizable offense made out in the information FIR has to be registered. Once FIR is registered, they look for material in support, and the truthfulness and falsity of allegations are matters of evidence to be led at trial. Right? Trial means your entire life goes. Entire life goes in trial. Now, in US, it's very difficult to initiate criminal proceedings. Very difficult. The matter is examined by the district attorney. He very reluctant to allow a criminal proceeding. The probable cause hearing in the US, when a person is arrested and is produced before the court, first thing is they will say, okay, we have arrested him for so-and-so, so-and-so. So the other side will say, we request for bail. Other side, the state will say, we oppose the bail. He's a flight risk. The other person here, the defense counsel will say, well, he's not a flight risk. He's a person who has deep roots in society. And the court will say, bail rejected, or will say that bail is fixed for $1 million or $500,000. That's all. This proceeding in India, we have the luxury of 4 to 5 years for this. What happens there in 2 minutes? Then we say that a system is clogged. 2 minutes it takes for this journey, which in India takes 4 to 5 years. Now, I will just basically say that there's another difference between US and India. There you have a jury trial. Thank God we don't have a jury trial here. Because you know what is the state of a society and what will happen to the people who are going to be members of the jury. Coming on to basic postulates of criminal law that everybody should know as a company secretary. There is a so-called presumption of innocence in India. I use the word so-called because it is something which one keeps shouting in the courts, and the judges also say, yeah, we know all about it. Even bail, jail is an offshoot of that. Innocent man, why should we put to jail? But you know, it is vice versa most of the times. Then, in civil cases, while the yardstick is beyond preponderance of probability, that is how the courts look at it. In criminal trials, it's beyond all reasonable doubt. Crime never dies. That's another postulate of the crime. That if a crime has been committed, even though the victim passes away, the state takes on the onus of responsibility. Now, what are the challenges here? And I'm actually happy that my learned friend has gone there. The biggest problem in India is police corruption. Civil offenses are given a flavor of criminal offenses, and they dispense with every notion of justice. You go to the cop, tell him, okay, here is the money in which so-and-so, they will register an FIR. Once FIR is registered, that even though you might have a heel which is 1 foot, in 1 year it will be reduced to just 1 inch. Itne dhakke khane padenge har jagah. Like I said, registration of FIR remains the biggest source of police corruption in the country. Arrest is at the drop of a hat. Harassment of trial, delay of trial. Now, I'll give a small illustration, and that will give you a flavor of how the system works in India. I might be criticizing, although I'm a part of the same system. I'll give you an example of Monica Bedi, that actress, her trial. As everybody is aware of it, that was Abu Salem, and I happened to represent her in that case. Her FIR was registered in 2001. In 2002, charge sheet was filed. She was taken into custody in Portugal, and in 2005, after 2 years of custody there, she was extradited to India. She was acquitted by the trial court in 2007. The appellate court upheld the acquittal in 2007. Her misery started from there. The state filed a revision in the High Court, and the Honorable High Court took a suo motu, cognizance, and revision was filed. So there were 2 revisions which were pending. Revisions kept pending till 2019 when they were both dismissed. After how many years? 13 years, when she didn't have a passport. An actress without a passport, 13, 14 years went, and after 1 year she got a passport back. So this is how delay tends to defeat the ends of justice in our country. Now I will also bring to your kind notice that today all the investigative agencies are first cousins. CBI, which is the first cousin of CBI? Enforcement Directorate. Another first cousin is Directorate of Revenue Intelligence. CBCID. Because the moment there is an FIR registered, a copy of the FIR is circulated to all these agencies, including investigation by the income tax. That department which deals with the investigation that company secretaries are more aware of. Now I'll give you an example of DRI. DRI, Enforcement Directorate, these are two agencies where the statement that you give before them is supposed to be statement under oath and it is admissible as evidence. Please mark this change. When you go before a police officer, he might threaten you, he might hit you, he might take a statement. That statement is not recognized by law. It is coerce, it is confession, whatever he might require, right? But as far as ED and DRI are concerned, these two agencies, whatever you say there, it is under oath, evidence. And how these people operate, I will give a small example. Demonetization. The moment demonetization took place, you know, all these agencies were in hyperactivity. So one of the cases I have done is with regard to some 435 kg of gold having been sold post the demonetization, which was supposed to be going abroad in the form of ornaments. And DRI was investigating. And I was really horrified to see that what we keep talking about police brutality, claps, boxes, revolver, pistol being kept on the table, pistol being put here, everything was done. Statements were taken and that was evidence against the clients. Enforcement Directorate. When you go to the Enforcement Directorate office, when you go to certain places, Gayatri Mantra is the one which is going on in the background. When you go to Enforcement Directorate, and I hope none of the company secretaries have to go, to get your morale up, you will get to know, Aye, bachao, bas kariye, main batata hu. These are the sounds which come. Now imagine you're sitting there with your files and this is what you are hearing, and this happens with CBI also. Now CBI has become slightly better. Enforcement Directorate has actually taken over. These are the things that you hear. And the amount they threaten you, no company secretary should go without a towel with him because a hanky will not be able to absorb the sweat that is going to be coming from the forehead. Better to take a towel. That is how they coerce. That is how they threaten. So again, now if that be the thing, what should be our strategy? Because ultimately as company secretaries, you can't run away from it. PMLA is such a draconian act. I will not take you through the definition, but definitely kindly have a look at the definition of what are proceeds of the crime. What are proceeds of the crime and what is money laundering? And every company secretary, like in the old movies, I wonder if anybody is there who belongs to the era when we had the movies where Ajit used to be one of the villains. And when he used to be in his gufa, and there was always a vakil also with him wearing a band. You would have seen that. So one chap would come running to him and say, "Ke boss, police aa gayi." Then he would take that spit inside and you could actually see the spit go down his throat. And then he would say something apart from that. And the poor lawyer used to be the first one jiske band ko kheech ke mukka padta tha by the hero. Now there are two management lessons which come out of this. Even at the stage when the investigative agencies were not that hyper and we didn't have the Enforcement Directorate working or the DRI working like that, all the people who were on the wrong side of law always had a lawyer with a band standing advising them. As company secretaries, please be mindful of one thing. You are the people who are like tandoori murga. You know, all the masala has been put by the owners most of the times, and especially I'm talking about privately owned companies, where tandoori murge ke uppar all the masalas have been put, and the fire ke uppar that is going to be made when the investigative agencies come. They will be far away. They'll be far away. So how do you prevent all that? There is a requirement for you all to get a prophylactic cover. What is a prophylactic cover? I will come on to that. So I'm not going to be touching upon IPC. I will not touch upon Benami, Negotiable Instrument Act. I just cover all that by saying that yes, these are the offenses for which one can be held liable. But the better thing, because this interaction, my experience is to tell you as to how to get out of sticky situations, and better still not land into one. Better still don't land into one. And for that, the best thing is something which I call as a prophylactic cover. Don't get into a situation that lifelong you'll be carrying files and running from one court to the other. Like I have said, there is most of the people in the societies that we live in, they do not know the difference between pre-arrest and pre-conviction and post-conviction arrest. If a person is arrested, it will come in the media, CS so-and-so arrested. Your family will be finding it very difficult to live in the society. It will be a Herculean task after that to get employment. So the thing is that people are not alive to the fact that, well, there is something which is known as a pre-conviction arrest, which is a part of the investigative process. Then there is something which is known as post-conviction bail. For them, it is both sides of the same coin. Loss of reputation, media, breaking news, company secretary ko uthaya gaya, company secretary ko ye kara gaya. I mean, where does your family go? So my request to you all is, whichever company you might be working with, wherever you might be a company secretary, try and convince your management that we want a legal prophylactic cover. Please focus on prevention. Prevention better than cure.
Hello.
As a part of the liability cover, what all aspects are there? The first aspect is that when a CS is made to sign his employment letter, please take it to a practitioner who is an expert in prophylactic cover, because he will be able to see through the lines and tell you that, boss, don't agree to this line. There is something hidden in this. Please do not sign your employment contract along with the terms and the conditions therein till the time you vet it from somebody. That's the first thing. Second thing, once you join, there should be a proper delegation of all the responsibilities. All the contracts which you are going to be signing, just don't sign it because the boss tells you, "Yaar, ye sign kar dena." You don't know what is the contract. You don't know whether there is a PMLA angle, because PMLA is very, very wide. You might get entangled there. You might get entangled in any other illegality. So kindly show the contract to a prophylactic professional who tells you, yes, it is safe to sign. If it is not safe to sign, don't sign it. That prophylactic professional will also be ensuring that all your contracts are in keeping with the latest law which is being enunciated by the constitutional courts. Because as you are aware, Supreme Court is churning out law every day. So are the constitutional high courts. Now, who's going to read that? It is not going to be the CSs who are going to be reading that. So there is a professional who goes through all the judgments as a matter of passion. He's the one who's the person who is most clued up as to what is the latest law on the subject, and he tries to dovetail your contracts, putting the latest law into the language of the contracts. Then you have to have institutional censors. Now, let's say there is an investigation, right? Investigation hui, the cops walk in and they ask, "Bhai, who's the one?" They say, "The CS saab hi hain, yahi sara kuch handle kar rahe hain." Now, as a CS, you have to have some kind of an interaction with your staff. You have to explain to them as to what is the hierarchy. You have to explain to them that, boss, this is what my role is, and this is what the higher management is doing. So basically protect yourself right from day one. Because when the cops come, they are going to take the name of the CS, because everything is going to be under the signature of the CS. And before you can say, "Jack Robinson, you are picked up again the same way," like I talked about the US courts where you're picked up like this and your legs are in the air, So kindly, please sensitize your environment where you're working. Please have institutional censors. You have to have creative incorporation of alternate dispute resolution mechanisms so as to ensure that the customers or the opposite side does not run to the courts at the first instance. Whenever there is a potential conflict which is brewing up, whenever, kindly don't start, shooting off the emails first and thereafter thinking. When the evidence is taken by the police, when the police takes the evidence, that's the time all the emails which have been written by us and the owners will at times, send us on WhatsApp ki ye bhej do. And CS Saab being, that is his master's voice. So what he does is that he immediately copies, pastes that and sends it across. When the police investigation takes place, he said, मैंने तो नहीं किया, ये तो CS ने करा है, आप उनसे पूछिए. आप बोलो, अरे इन्होंने बोला था, वो कहते हैं, अच्छा. You get the point? I'm not trying to put in an element of distrust. But today are very dangerous times. Today are times when civil law has taken a backseat and criminal law is the one which is pervading everywhere. Civil disputes at the drop of a hat are being given a texture of criminal cases, arm twisted, and that's how the solution is being found. Kindly safeguard yourselves from all these things. Most important thing is that cases are not lost or won on law. This is a notion which you must dispel. They are won on strategy. Now, we lawyers don't want company secretaries or any other professionals to start using their brains. Because it's something like if a pandit, you go to a pandit and you tell him, वो कोई मंत्र पढ़ रहे हैं और मैं बोलूं कि जी मुझे पता है मैं पढ़ लेता हूं, वो कहेगा अरे मेरे 100 रुपए कम हो गए. तो वो कहेगा ना मेरे को बोलना है, as if he has a direct connect with God, कि उन्हीं की आवाज से जो है भगवान सुनेंगे. We lawyers are also like that. We don't want you all to start using your brains, because the moment you start using your brains, we'll say, अच्छा आप बहुत ज्यादा ज्ञानी हो, आप ही कर लो. Kindly make the strategy yourself. Strategy requires common sense. Make the strategy yourself. Bounce it off him. Ask questions. Why this? Why not that? Because ultimately it is not his neck which is there on the line. It is your neck. It is the neck of your company. Corporates are basically, you talk to any person, and I'm sure most of the company secretaries are going to carry this to their owners or their management. Hey, let's have a prophylactic cover. They'll say, why spend money? Let's not spend money. क्यों पैसा waste करने की बात करते रहते हो? So that's the 25 पैसे वाली mentality. आपने 25 पैसे बचा लिए. When there is an issue, you will end up spending 2,50,000 rupees. That is why what happens in US, and I am drawing that analogy because I am doing extensively work there. There, any corporate earmarks nearly 10% of whatever is the gross profit on the legal prophylactic cover. Everything is run through the advocates because they want to avoid, losing their entire capital to litigation, because there, suits can be multi-billion dollar, $1 million so bada common hai. So they want to protect themselves by spending 10 paise rather than spending 1,000 rupees when you have 100 rupees. Now I'll give you a few examples. Because when I talk so much about it, I'll talk about a few examples as to where the prophylactic cover has been something which has been really, it has come in very handy during the Corona times. Now before the Corona, as you are aware, a lot of people keep buying these Mercedes-Benz cars, BMW cars and all that. So, I mean, one of the big dealers is my client where I'm giving prophylactic cover to them. Any person who had bought the car prior to March of 2020, it might have been 19, 18, whatever. As you are aware, in Delhi, it's only 10 years the life of the diesel car is. वो 10 साल के अंदर भी कोरोना हो गई और लॉकडाउन हो गई. There were people who were paying EMIs and they didn't want to keep the car. So the simple thing was to send a legal notice. And when I talk about legal notice, I'm talking about legal notices which were nearly 300 from 300 different customers. You have cheated us. You have made misrepresentation to us. Now you please take the car back and give us 20 lakh rupees for damages. Otherwise, we will do EPCD. Right? This is where criminal law and law was being used to basically for an oblique motive. Prior to the time when I got involved, as a matter of philosophy, they would want to do business and not get into any kind of a confrontation with the customers. So they would jod up their haath and they might have compromised with regard to 20 lakh ki jagah 2 lakh de diye, 5 lakh de diye, car wapis le li. That is something which happened. Out of nearly 300 odd legal notices and police complaints which were there, we filed a reply, and with every complaint to the police, we filed a cross complaint. Out of 300 such cases, not one went to the court. They were all settled, and not one FIR was registered because हमने cops को बोला, you want to register it, कर दीजिए, लेकिन cross भी करनी पड़ेगी. So that is one thing where the prophylactic cover came in handy. Now I will also give an example of a very big group without taking a name, based out of UK, wherein during the good old times when Gali Janardhan and all these mining cases were going on, where they would just buy the material without, they would excavate the material without any royalty paid to the government. They would just export it to China and all these countries without 0%, royalty being given to the government. These were the unfortunate people who had bought this zero material from one of the people who was selling the zero material, and there was a PE by the CBI. So first day when they appeared, that guy actually came back and he said, the representative who had gone, कहता मैं दोबारा नहीं जाऊंगा. He gave his resignation to the company. So the boss of the company said, no, we'll give you all protection. तो उसको armor protection दे दी, लेकिन भेजा उसी को battle में. And then they contacted me. I went along with him. So what was the requirement of the day was that we made an entire strategy for trial, that if this matter was to go to trial, this is going to be our explanation before the trial court to succeed in the matter. Then we worked backwards towards investigation and preliminary inquiry. Statements were given like that in consonance with the truth, of course, which we would have actually raised at that stage of trial. And the PE, preliminary inquiry by the CBI with regard to a mining case was closed. This is another prophylactic leg. It does not mean that just because there is a notice which is given by the CBI for preliminary inquiry, it is doomsday for you. You can take prophylactic measures even at that stage. It is not the end of the world. But please don't just walk into a police station. Don't walk into the CBI and never walk in before the ED when you get a summon from them without protection, without consulting, and without some armor protection here, because it's very difficult. You have to basically, make your brain strong. I'll give a very small example again. It's on the lighter side because I know my lecture, so-called interaction, is getting too heavy. My learned friend has been in the police. So, before I used to take my people to either the police or the CBI, enforcement directorate included, because I have been accompanying them, because my clients have said that till the time you come along with us, हम नहीं जा रहे. जो भी हो जाए, उठा के ले जाए, कोई बात नहीं, भाग जाएंगे हम लोग. But we will not go. So I have accompanied them, and it has been a wonderful experience. And before that, I have, made them sit and done a mock interrogation with them. Most of the people, all these big shots, baniyas and all that, who think that they are cat's whiskers, हमारी इतनी कंपनी है, इतना टर्नओवर है, उसमें टर्नओवर में कितना परसेंटेज बैंक का है वो मत पूछिए. 99% bank money, but we have got, thousands of crores and all that. Then they would sit like this. I'm sorry, my hand is broken, I can't show it, but one leg over the other, आराम से पीछे बैठ के ना, sit like this. ऐसे थप्पड़ पड़ेगा, वो हाथ extend करके थप्पड़ मारेगा if you sit like this. You have to sit on the edge of the seat. And more often than not, most of the people went like this, sitting on the edge of the seat, and the investigating officer would say, अरे क्या कर रहे हैं? अब मैं खाएगा क्या तुम्हें? मैं खाएगा, आराम से बैठो, आराम से बैठो. So you see, you set the tone wherein the person is already sympathetic and he knows that you are very, very scared, and he's trying to put you at ease rather than try to show that I'm cat's whiskers. वो कहता है मैं बताता हूँ तुम्हें, थप्पड़ मार के थप्पड़ एक मारेगा, सारा कुछ गुल हो जाता है. Right? So that was on the lighter side. Now I'll give you some other examples. As company secretaries, I'm sorry, I'm going more on the practical side because of the experience that I have, and I think that it will be more beneficial for company secretaries. So I'm cutting short on the academic part and trying to take you on the illustrations more.
Sir,
Now,
can you please highlight on Sf5 matters? Because most of the company secretaries would be appearing before Sf5 or going over there as a key managerial personnel. So your experience, if you can kindly throw a light on that, please.
When I say investigation, the contours of investigation are more or less the same with Sf5, although I would say that Sf5 is a not too bad a place to go to as compared to the ones that I'm talking about. So when you prepare for the worst, then you are prepared for actually the better ones. SFIO investigation is also, as you are aware, that there are various parameters which are set out in the company law, wherein an investigation can be directed by the central government with regard to affairs of the company, and SFIO is the one which is entrusted. Rarely will you see any arrests being carried out by the SFIO. Normally, as a matter of course, they don't do it. As a matter of course, there might be isolated instances where this might happen. But as far as SFIO is concerned, if you have to go there, prior to that, please sit on the drawing board with your advocate and make out a strategy if the case was to go to trial on a complaint of the SFIO. Please don't walk to any investigation thinking, okay, yes, I'm prepared for the investigation. Wrong. It's a wrong way of going to the investigation or inquiry. When there is an investigation, you see that all right, if the investigation was to go before a trial court on a complaint by the SFIO, or let's say in the case of other places like charge sheet by the CBI or DRI ka complaint or Enforcement Directorate ka complaint, then what is going to be a strategy for trial there? Because then you have to work backwards. When you go before the SFIO, your people are going to be giving statements. The case of the SFIO is going to be predicated on the statements. What statement are they going to give unless and until you know that this is the strategy for trial? Unless and until it is like, I'll give you an example, that let's say there is a movie. We have lots of movies wherein the story is something which is not told to any of the actors. There is a beautiful movie with 4 frontline actors, and scene after scene they are acting, and when they all put together तो पता लगता है कि वो जानी दुश्मन बन गई. वो पुरानी जानी दुश्मन एक पिक्चर थी जिसके अंदर every top actor was there and you have to punish somebody to tie him with the seat and say कि तेरे को ये picture देखनी है, that is your interrogation. So let us not get into that kind of a situation. What you must do is that please go and prepare for trial. That if this matter was to go there, these are the allegations. What is our explanation with regard to that? Now, if that be your explanation with regard to that, who are the people who are going to carry this explanation before the investigative agency? Who are the people? The witnesses. Which witness is going to be saying what? And please don't misunderstand me by a long shot as trying to say that conjure up a false case. I'm not saying that. All I'm saying is get your act together, because I go on the presumption that you would have done no wrong, and you only have to conjure your defense at the stage of investigation, whether it is by the FIO, whether it is by CBI or any other investigative agency. Have I answered your question, or do you want me to?
Yes, you have answered. You have answered.
Right. So now there was a very big corporate in Bombay at one time. Today the person is struggling. I was told, and one of the company secretaries had come to me to consult me, that initially in the very first month he was in awe of the person. He was made to do a lot many things on paper, put his signatures on a lot of documents, and subsequently when he realized that things were not okay, which he realized after 2 years, then the person told him across the table, boss, you are the person, तुम्हारे against तो मैं FIR कराता हूँ. You have done A, B, C, D, मुझे क्या तुम expose करोगे? You are the one who has signed everywhere for me. That poor guy continued with him till the time that guy got into major trouble, ultimately had to become an approver to get out of the case. So the first thing is that please be very, very careful, and I'm not saying that you should be distrustful, but you must be careful with regard to your employers as to how they are trying to bestow responsibility on you. What is there in the contract? What are the emails they are asking you to send? Kindly go to a person who is on your panel with regard to prophylactic legal cover. He will help you out with regard to all these things. Because company secretaries, poor guys, they are under employment. They are on a salary. Right? And if tomorrow you get into a trouble, you will have to dig into your pocket, which is already torn. Most of you guys are not going to be able to afford a criminal trial. You will not be able to afford a big lawyer supporting you. So kindly just try to convince these guys to have a prophylactic leg as a part of the advisory team who can help you and the corporate remain out of trouble. Then the famous thing of quid pro quo. The moment any person, any CS today hears quid pro quo, every person has that fear going down his spine. the entire case of Jagan Mohan Reddy is quid pro quo. Allegations of the CBI are, well, this land was given and this much of money was invested into the company at unrealistic valuations. This is what the allegation is. Now imagine the company secretary who was a part of the process of those companies and in good faith has signed everywhere. What is going to happen to him? So as company secretaries, it is much better to say no rather than to regret the rest of your life to say कि मैंने no क्यों नहीं बोला. And there is a diplomatic way of doing it. You protect the employer also and protect yourself. Most of, and I will also just go aside a little bit, in a very big case of CBI in Hyderabad, one of the owners, it was a very high profile case, lot of reporting in the media, and the person who was arrested was a financial guy, a company secretary. I don't think he was a company secretary, I think a CA. He was arrested, he was the CFO of the company. And imagine the owner comes and tells me, "Hey, yaar, aisa karo, that you fight for him, but ensure that he remains inside." I said, "Why?" He said, "Jaise ye bahar aaya, then there is going to be a clamor by the CBI to have representation in the jail. It is better that he stays there rather than I have to go into the jail." And you know what I told him at that time? That person, you are the tail of the elephant. Now you want to get out of the door, take the tail out of the door. He is the body of the elephant and CSS are the body of the elephant. Please explain it to your owners and the management. You can't say that, कि हम बच जाएं और ये फंस जाए. ऐसा नहीं होगा. So please save them. We'll say that we'll walk the entire elephant out of the door. Now, unless you have a problem. So nobody will have a problem with regard to that.
May I request you kindly conclude, please?
All right.
For the initial opening remarks.
Okay. So now I will just a few points which you should keep in mind. Whenever there is anything which is brewing up, whenever there is any crisis brewing up, any kind of a problem brewing up, do not send a mail without consulting somebody. Because that mail is something which is a documentary evidence which is going to be read against you. Be very careful, mindful when the owners themselves send you drafts on WhatsApp and say कि ये भेज देना. Number one. Number two, your call data records are very important. Please be mindful that if tomorrow there is an investigation, the call data records are going to be the first thing which are summoned. So please ensure that you do not get in touch with those people where the owners don't want to get in touch and you make the mistake of using your phone to get in touch with them. And third thing is that as a company secretary, by no means am I saying that don't do your work diligently. But all I'm trying to say is that while saving the companies, please save yourself first because you are the body of the elephant. The company is the tail. So that is all. And if there are any questions, I'm willing to answer, or towards the end, if you want, we can have it towards the end.
Yeah, towards the end we will have, but before I request Makhija ji, one small question. Is not that indoor management can save the professionals?
These are all academic, very, very academic questions. The moment you talk about indoor management, doctrine of indoor management to a police officer, well, he will do some other kind of indoor management. And there are other things also in criminal law, like okay, fine. Just to go a step further, earlier on, the company's liability was restricted. Now the Supreme Court has extended the liability of the companies. There is alter ego. Those people who are running the affairs of the company, they are held to be responsible for the affairs of the company, along with the company. So indoor management will not come to your rescue. It might come to your rescue with regard to company law, but indoor management is not going to come to your rescue with regard to criminal law.
Thank you so much, Ahluwalia ji, for your opening remark as well as address. Now we have Shri Ashish Makhija ji, who is also a well-known personality. He is an advocate and director, AMC Law Firm. He has done his LLM from Thomas Jefferson School of Law, San Diego, California, 2012. Kurukshetra University of India, LLM 2010. University of Delhi, LLB 2003. Fellow member of the Institute of Chartered Accountants of India, and is also a fellow member of the Institute of Cost Accountants of India. And he has the membership of Supreme Court Bar Association, Delhi High Court Bar Association, Indian Council of Arbitration, NCLT Bar Association, and he practices in the area of corporate law, business law, financial crimes, bankruptcy, litigation, as well as more so on the disciplinary front on disciplinary matters. May I now request Sri Ashish Makhija ji to kindly appraise our members with regards to more so in terms of the disciplinary proceedings which takes place in the institute, both the company secretaries as well as the chartered accountants, because you will find the members are twinly qualified. So in that connection, I would request you to kindly throw the light on disciplinary proceedings, please.
So, first of all, I must thank Institute of Company Secretaries for inviting me, and I appreciate the efforts of all office bearers, including Mr. C.S. Nagendra D. Rao. I think these are very important subjects, and the practical aspects are extremely important. Well, I think I was hearing my colleagues out here, the panelists who were speaking before me on criminal law, particularly talking about the investigations by CBI and under FEMA and PMLA. Well, hearing them was definitely scary. But friends, let me tell you, as a professional, I also deal with all these matters. There's nothing to be scared of. The only thing which needs to be done is that you need to create a safety net around you. This is extremely important. And that safety net starts from you only. So what kind of documents you are signing, whether they are, because you see, you look at the motto of your own institute. Now, what is that motto? If we look at the motto, it says, speak the truth, abide by law, isn't it? So therefore, what is extremely crucial, my dear friends, is that if you speak the truth, you don't have to remember anything. Number two, if you abide by law, where is the worry? Where is the question? Of course, there may be an investigation. There may be an inquiry against you. You may have to face some harassment for some time, but at the end of the day, the truth is something which nobody can defeat that. So therefore, I think we need to believe in that. That's our legal system, and I think we should believe in that. Now, having said that, before I come to the disciplinary part, which is again a very, very important aspect, friends, let me deal or share my experience with two little aspects, particularly in relation to the Sfio inquiries. Well, friends, Sfio inquiries are not as dangerous as PMLA or ED or whatever other departments are there, or CBI inquiries are there, because there are more in criminal nature. Here, of course, in Companies Act also, we are talking about criminality, because the punishment when we talk about. Two things are very important, friends. As Company Secretary, I think you have read through the Companies Act and all other corporate laws and other related business laws. But have you read Section 447 of the Companies Act? Now that's actually the most important part of it. If you look at the definition of the fraud which is given in explanation in 447, I think it is one of the widest definition I've ever seen. If you look at the definition of course, the fraud has not been defined in CRPC or IPC, but the word fraudulent has been defined. But if you look at the definition of the fraud, it is a very, very wide definition. And if you look at that definition, you will find the use of the word any number of times. Very liberally, the word any has been used. It says fraud in relation to the affairs of the company or any body corporate includes. So it's an inclusive definition. It's not a meaning definition. Then it starts and takes off and starts with the word any act. Omission, concealment of any fact or abuse of position committed by any person or any other person with the connivance in any manner. Look at the scope. I mean, the word is any is used with so much liberally, with intent to deceive, to gain undue advantage, or to injure the interest of the company or its shareholders or creditors or any other person. Now, I am very doubtful where you use the word any other person, whether or not there is any wrongful gain or wrongful loss. Now, the last sentence is the most dangerous. In criminal law, my dear friends, the wrongful gain and wrongful loss are very important aspects to be proved and demonstrated in a court of law, particularly in case of financial frauds and all, and even in other criminal acts also. But in companies, particularly Section 447 very clearly rules out, it says whether or not there is any wrongful gain or wrongful. So this is a very, very huge and wide definition which you must take care of it. Now coming to the powers of the SFIO. SFIO has the power to arrest also. And these were not notified when the Companies Act was notified in 2014. Section 212 subsection 8 was notified only in 2017, I think somewhere around 24th August 2017. Now that is the date when the SFIO got powers to arrest all. Earlier they had the power to investigate. There are two types of inspections and investigation. There is a slight difference. Inspection is a little lighter word. Investigation is little a serious term. Now, if you look at the power to arrest, now please read section 212 subsection 6 also. That is also very important. And it clearly says that this particular provision is not subject to even anything contained in the Criminal Procedure Code, CRPC also. There are bail conditions which are mentioned in 437, 439 of CRPC, but if you look at section 212(6), it says that no bail shall be granted for the offences committed under 447 unless two more conditions are satisfied. And those two conditions are that the public prosecutor has been given an opportunity to oppose the application for such release. And two, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and he is not likely to commit any offence on such bail. Now, these are two additional conditions. So, therefore, these becomes very, very stricter terms. Well, here there are two judgments also which I want to share with you. One is Nikesh Tarachand Shah versus Union of India. This is the 2018. If you want a citation, I can give you also. 2018 11 SCC 1. This is Nikesh Tarachand Shah versus Union of India. I'll repeat, 2018 11 SCC 1. Now, this was not under Companies Act. Of course, this was under PMLA. There are two additional conditions in Section 45 of PMLA, which is quite similar to what we have in Companies Act, and they were struck down by the Supreme Court, saying that these are the unlawful, unreasonable infringement on the rights of the accused under Article 14 and 21 of the Constitution. But that is 2018. Now, here we have a another judgment of Delhi High Court, which is very close, and that is SFIO. There's an SFIO case, SFIO versus Nitin Johri. Now, that is 2019 9 SCC 165. I'll repeat, SFIO versus Nitin Johri, 2019 9 SCC 165. Here, the Supreme Court actually cancelled the bail which was granted by the Delhi High Court on the grounds that the twin preconditions prescribed under 212(6) and the general principles of granting the bail were not satisfied. So therefore, friends, these are despite the fact those additional conditions were struck down under PMLA, the Supreme Court held that no, these two conditions have to be satisfied in this particular judgment. So these are two contrary judgments to that extent. So therefore, in criminal law, you need to be prepared. That's what my predecessor, the previous panelist was also mentioning. And he said that only strategy will win you. In fact, and not the law of the case. I will say even the facts of the case will not win you the case. So facts and law, you have to leave aside, you have to strategize. There is definitely no quarrel or no discussion on that part. So now coming to the SFIO inquiries which are, which are undertaken. SFIO consists of people drawn from various fields. Some are retired police officers who are now working in SFIO or they are on deputation. Some people have been taken from, say, SEBI, some are from RBI, some are from income tax. Of course, there are company law officers who are also there. So it is an amalgam of various, inspectors who are there. And they always try to play, like all police officers, they will investigate you not alone, but in the presence of 2-3 people. And they will always play a good cop, bad cop kind of a situation. So one will kind of threaten you and one will kind of, be on your side. So will try to comfort you. So those kind of good cop, bad cop, situation will be there. But you should always, speak the truth and based on the papers which are available. And whenever, the inquiry goes on, I always tell people, and that's a very funny part of it, I don't know how far that can be utilized, but that always happens. That memory can go anytime and memory can come back anytime. So you can always use this kind of a thing. And if you don't understand a question, let me tell you, you must ask them to rephrase that question before jumping to answer. So it's very important that you should understand the question first. And if you are not remembering certain thing, please do not answer it. You say, we'll have to refer back to the papers. And that becomes very, very important. I'm not saying that you should hide papers. Definitely, whatever papers are available in the corporate world, you will have to hand it over. There is no option. And so therefore, the one more important aspect, the papers which has been drafted like minutes of the meeting or anything, now you need to really concentrate on that when you are primarily creating those papers or making those papers. You have to protect yourself. The safety net actually starts from there. So it's very important that the promoters of the company will always want to protect themselves. I'll give you one more example. One of the companies, very large companies, they faced with an income tax raid or raid from some other department also. Now the whole group actually came to me, said, we want to strategize that tomorrow the promoters are not harassed. Even in income tax, they were being asked to report at 9 a.m. in the morning, and they were asked to go back at 6 p.m. in the evening. And no question was being asked. They were just sitting outside the office of the assessing office or the commissioner. So these are the problems or the harassments which start. So the promoters never wanted to face that. And they said, please restructure the whole thing so that every responsibility goes to our employees and not to us. Well, that is possible. If you look at Companies Act, you can always strategize that also. Well, be that as it may, even if you are a key managerial personnel, which you are in any case under the Companies Act, you shoulder that certain responsibilities. But within those parameters, within those sphere or responsibility, now you should protect yourself by having the papers in support. That's what I'm suggesting out here. Now coming to the disciplinary part of it, friends, now this is extremely important because not only the criminal matters, but what the most of the company secretaries or chartered accountants or professionals are afraid of are that if they are held guilty of professional or other misconduct, please remember the two words, professional misconduct and other misconduct. Both are covered under your Company Secretaries Act, which covers both of these areas. Now, why? And I must tell you, whenever a notice comes from a disciplinary directorate of Institute of Company Secretaries or any other institute, most of the professionals who come to me, now they will not even open the envelope, and they will simply give it to me. He says, "Sir, you open it. हमें तो बहुत डर लगता है. We are afraid of opening it." So even a letter from a disciplinary committee becomes very dangerous for the professionals. And whether you are in practice or whether you are in employment, you have to take care because professional or other misconduct covers both the things. I remember a kid, I remember a quote actually, integrity without knowledge is weak and useless, and knowledge without integrity is dangerous and dreadful. So therefore, whenever you are having obviously you have an extreme knowledge because you are a company secretary, you are a professional, but you need to work with integrity. This is extremely important. And ethics is something, knowing the difference between what you have a right to do and what is right to do. So this is very, very important. You may have a right to do something, but what is right and wrong, I think no one can make a choice. Only you can make a choice. Nobody can force you to make a choice. And in case you are forced to sign certain documents which you believe, then I always say either fight or take a flight. So you will have to decide between your personal integrity, professional integrity, and also the peace of mind. That's very, very important. So why would we need a code of conduct? Let's go back to that and let's understand that. Number one, integrity, which we have already discussed. Two, professional independence. Because as a professional, when we are appending our signatures on any document, including the financial statements, the public actually believes that. So therefore, if we do not work in an independent manner, then that thing is lost, and then there could be a case of professional misconduct. We are professionally competent, but definitely for professional competence, we have to work in a professional environment. And if we do not behave professionally, even in our personal lives, well, we can be held guilty for other misconduct. You remember a case which came into newspapers, a chartered accountant. Well, he was on a plane. He threatened that, he made a call for hijacking the plane. Well, he was held guilty under the criminal law. But even the Institute of Chartered Accountants started a professional misconduct and other misconduct inquiry, disciplinary inquiry against him, and he was held guilty under that also. Though it was not a professional work or related to his professional competence. But still, they say that if you are behaving in public, you ought to behave like a professional. And that is why I always tell, the company secretaries and chartered accountants that whenever, even if you get into an accident on a road, in a road rage case, well, you may fight or you may abuse somebody, but don't say that you are a company secretary, right? Or you have a company secretary sticker on that, so be careful. Because not only there can be an FIR against your action, there can be a disciplinary inquiry also if the person knows that you are a company secretary or a chartered accountant. So be careful on that. Objectivity. Now that's also very, very important. That code of conduct is required because of the objectivity, ethical behavior. Now, everyone is bound by ethics. Now, if I work with ethics, I don't think I have to fear anything about it. Then, of course, conforming to the standards, the technical standards or secretarial standards or confidentiality, these are certain areas which are also very, very important. Now, coming to the disciplinary part of it, first I'll give you the overview of what the disciplinary mechanism is, and then we will deal with few very, very specific cases. And if you have any questions, then we will be able to answer that. Chapter 5 of the Company Secretaries Act 1980 is extremely important. And you have to read it with the first and second schedule. And there are rules which have been created now, procedure of investigation and professional and other misconduct and conduct of cases rules, which are very long rules are there, but they will have to be read along with it. Now, I will draw your attention to one of the important sections, which is section 22. Section 22 actually defines professional misconduct, and it covers in its ambit, friends, act or omission provided in first or second schedule and other misconduct under any other circumstances. So other misconduct under any other circumstances is very, very wide. And those who have faced, disciplinary inquiries, I think they know that, even in these circumstances, things can change very, very quickly, and they are very, very big. They take, a very, you can say, they hit you very hard in the sense that as a professional, you are getting your employment based on your professional degree. You enjoy a status in the society because of your professionalism. Now, if somebody takes your professional degree and you are thrown out of a profession or debarred from practicing, imagine what is the situation of that person. Because it takes, a lifetime to build a reputation and goodwill, but it can be spoiled even in a single stroke of a pen. So therefore, one has to be extremely careful as far as the schedules of professional misconduct is concerned. Now, friends, I'll just give you an overview. I mentioned that there are two schedules which are attached to the Company Secretaries Act. First schedule, there are first schedule and second schedule. The difference between first schedule and second schedule is like this. First schedule deals with some internal kind of a thing which are not, they are between the company secretaries and those kind of issues which arise. So power to adjudicate and punish lies with the Board of Discipline. So Board of Discipline has got the powers to deal with the professional misconduct matters listed out in first schedule. The second schedule, I would say, is more dangerous because it talks about the negligence, it talks about the other things, the due diligence, not done with due diligence. That means outside word is also involved here. So here the power to adjudicate and punish lies with the discipline committee. Now, if there are certain offenses or acts which are falling under first schedule as well as second schedule, then obviously the power will lie before the disciplinary committee. So there are two adjudicating authorities like Board of Discipline and Disciplinary Committee. So Board of Discipline deals with only first schedule. Disciplinary Committee will deal with second schedule or first schedule plus second schedule if second schedule is involved. So those kind of things are there. So now how the cases are tackled once a complaint is filed or based on any information. Now the matter goes to Director Discipline. Director Discipline is an autonomous, not an autonomous body. In fact, it's basically within the institute, but obviously the Director Discipline investigates on the basis of the complaint or the information. That means once a complaint is received, a copy is sent to the company secretary. Then that company secretary responds. That reply is given to the complainant if it is a complaint case, and the rejoinder is asked for. Based on these three documents, then a prima facie opinion is made whether the professional is guilty under the first schedule. If it is so, then the matter is referred to Board of Discipline. If the professional is prima facie held to be guilty of second schedule or first and second schedule both, then the matter is referred to the Disciplinary Committee. So these are the two committees where they come into picture. And then Board of Discipline consists of 3 members, and the Secretary is the Director Discipline. The process between the Board of Discipline and the Disciplinary Committee is little different, because Board of Discipline is kind of a summary procedure where witnesses cannot be examined. But in case of a disciplinary directorate, it's a full-fledged disciplinary proceeding, so where the witnesses can also be called and examined by the Disciplinary Committee. So if the Board of Discipline comes at an opinion that the member is guilty of professional or other misconduct, definitely after giving a hearing is always afforded, then they can take any of the 3 actions. 1, they can reprimand the member, they can remove the name of the member up to 3 months only, or they can also impose a fine up to 1 lakh. And they can do removal of name up to 3 months and imposition of fine, both can also be done. So these are the 3, actions which they can take. Now the powers of the Disciplinary Committee are little more, so therefore we have 5 members. President or Vice President acts as a presiding officer. Then there are 2 council members and 2 central government nominees are there. And they have to follow a specified procedure. If you look at the rules, rule number 18, talks about the major things, how the proceedings will be conducted. But obviously they take into account the natural justice. Once the prima facie opinion is made by the disciplinary Director Discipline, then that is issued to the professional, and the professional is given another chance to make his submission. So, and in case they arrive at an opinion that the member is guilty of professional or other misconduct, then they can reprimand, they can remove the name of the member permanently or up to a certain period. So their powers are more than the Board of Discipline. Board of Discipline can remove the name of a member only up to 3 months. But here, the Disciplinary Committee has got power to remove the name of members permanently. In case of Chartered Accountant, one of the Chartered Accountant, he wrote a book that how to create black money. So this kind of a book was written by him, and the matter was referred to the Disciplinary Committee, and he was removed permanently. He was thought unfit to act as a chartered accountant. So friends, these kind of actions have been taken. So please be careful. Where more than 10 years, 15 years, they have also been debarred from practicing. And the fine can be imposed up to rupees 5 lakh. So this is the broad, overview of the Disciplinary Committee and the Board of Discipline. But one of the important aspects is that the Disciplinary Committee, Board of Discipline, and the Director Discipline, all of the 3, they have got powers of the civil court while summoning, enforcing attendance, examining on oath, discovery and production of any document, or receiving evidence on affidavit. They have got huge powers which have been conferred to them under the Company Secretary Act, and they can enjoy these powers of civil court also. That means they can call for witnesses, they can summon them, they can enforce their attendance, and they can examine them on oath. So this is also very important power which is there. Now, coming to one of the important aspects is that how to handle these cases. Friends, number one, if such case or say complaint is received from the director discipline or disciplinary directorate, well, don't be afraid. But remember to take the professional help at that stage only. Why I am saying so? You can fight any case because you are professional yourself. But for your fighting your own case, you are too emotional. You are aware of too many facts. So how to present that case becomes difficult. So therefore, it is very important to take a professional help in such matters from the first stage itself. Because whatever you say in the first reply, that sometimes becomes an evidence. And that you cannot deny later on. So therefore, the proper reply has to go even from the first stage. So I will say, what to disclose is important, but what not to disclose is sometimes also becomes important or relevant. Because in the heat of the moment, you may say something which you regret later on. So therefore, it is always advisable to take a professional help even at the first stage itself. So strategize your case. That is extremely important even in disciplinary matters. And thereafter, of course, your attempt should be that even at the first stage, cooperate with the director discipline and try to convince the director discipline through your replies that even a prima facie case has not made. Because if that report comes in your favor, obviously it is taken into consideration by the board of discipline. Otherwise, of course, they have got powers to overturn that also and still refer the matter to the board of discipline or director discipline, depending on which schedule is referred to. Be that as it may, that is the first stage. Even if you are unsuccessful at the first stage, you get a second chance before the board of discipline or the director or the disciplinary committee. So if you want to bring any evidences, that is to be done by way of an affidavit before the board of discipline. But in case of director disciplinary committee, you can obviously call the witnesses also. Now, there is one aspect which is very important is, supposing there is a criminal case which is filed against you, or some criminal inquiry by CBI is going on, and simultaneously institute also starts suo moto some disciplinary inquiry against you. Now, the biggest question which is asked to me is, can these disciplinary proceedings go on despite the fact that the criminal matter is also pending? Well, friends, there is one of the important judgment of the Supreme Court. First of all, I would like to mention that, which is H.C. Pancharappa judgment of 3-member bench of Supreme Court, which says that the disciplinary cases against a professional, that was a case of an advocate, they are quasi-criminal in nature. Quasi-criminal in nature means, and they have mentioned that, and not only in one judgment, in later on judgments also, that these cases are to be proved beyond a reasonable doubt. And they will not have to be proved on preponderance of probabilities as we do deal in a civil matter. So quasi-criminal cases, they are considered. Number one. Having said that, so therefore, your opinion should be that if there is, supposing a CBI, like in a case of a Satyam, let's take an example of Satyam. My learned friend was my previous panelist. I think he was mentioning about a case from Hyderabad. Probably he was referring to Satyam matter only. So in Satyam matter, obviously CBI filed a charge sheet against the CFO, against the internal auditor, even the statutory auditors also, and probably against the company secretary also. But and besides that, there was a disciplinary inquiry which started against the statutory auditors and the internal auditors, and the CFO was also a chartered. Now the plea which they took before the High Court, because they filed a writ also, that look, there is a criminal matter which is going on. I have to give an evidence. Today, if the Institute of Chartered Accountant proceeds against me, it is number one, will lead to a double jeopardy, number one. Number two, I am forced to disclose an evidence before the Institute of Chartered Accountants, which I am protected under the Constitution of India, Article 20. Now, these are the few points which they took. But unfortunately, Delhi High Court Division Bench decided against. They said that the disciplinary inquiries are on a different platform altogether. They are dealing with the fate of the professional, whether he should continue as a professional or not, and they are not dependent on the criminal inquiry. So therefore, they segregated that, and therefore the conclusion is that disciplinary inquiries can still go on despite the fact that there is a criminal case which is pending against a professor, but on a similar ground, on a same matter also. So friends,
Makhija ji, just last 2 minutes so that then we can take questions, please.
Sure, absolutely. I think I'm just about to finish only. So this is the lesson which we learn from these cases, that we have to protect ourselves. This is very, very important, friends. Only suggestion I can give you is that the moment any inquiry starts, the moment any letter from the disciplinary committee comes or the disciplinary directorate comes, don't be afraid. Don't panic. I think if you have not done anything wrong, the papers support you. It may take time. Obviously, these proceedings will hang on for a while. But ultimately, if you have not done anything, you will be able to demonstrate from your papers. So nothing to be worried about. The only aspect is, please take professional help as quickly as possible and rely on that help so that you cover your major grounds on that. So friends, with these words, I'll just end up my presentation and hand over the proceedings to Mr. Nagendra Reddy Rao.
Thank you, Makhija ji. Thank you very much for your excellent presentation. My first question to Shri Krishna Bhatta is that though during the deliberation there was a mention about that it is a notice which is sent to the company secretary or any professional under section 160, and when it is a notice which has been sent and exceptions what we are taking is about good faith, whether the chances according to you turning from just a mere witness to an accused, as per your experience, sir, how much do you feel that the transfer takes place from the witness to that of an accused person, and whether a person who comes with a good faith before the respectable police officers, whether it is appropriate for the professional to go, the question mark comes.
Yeah. I would like to answer this in a different way. Learned advocate Sri Jagdit Singh ji, Alwani ji, of course, said so many harassment by police investigating agencies. Yes, that might have happened, but that may not be the case. That is not a general thing. It may be a specific thing. It cannot be generally applied to the entire police department. In my 31 years of service, I have not come across any case in which a person is called for recording of statement after issuing notice under 160 Crpc. He has never been made an accused. In my 31 years of experience, I have handled many cases. I was with the Karnataka State CID also, and many very sensational cases we have handled. In none of the cases, we have not made any person who is called under 160 Crpc an accused later. We have not done that. So this is the answer to that question which was raised by Mr. Nagendra Rao. Next one, of course, I didn't understand. Mr. Nagendra Rao, could you please repeat it?
Yeah, what I'm trying to say is a person comes with a good faith before the police personalities over there, and he will be shocked when from witness he is converted into an accused.
No. I have not come across any such things. As far as Karnataka police is concerned, in which during my period of my service in the police department, I have not done that. Yeah, we have not done that. And usually police officers also, they are also human beings. They understand. There may be aberrations. There may be a few persons who would have brought disrepute to the police department, but that is not generally applicable. It may be a specific case, maybe an aberration, as I told. That is my answer.
Okay. Going forward with the same question, with regards to just by having the strategies in place and appearing before the police authorities, whether normally we talk about Satyam Vada Dharmam Chara, the motto of our institute also, but by making strategies, whether it works out in the interest of the either a witness as a professional before a police authorities.
No, the first word you told, could you please repeat?
I'm saying just mere strategy, how to tackle a particular situation and appearing before a police authorities, whether that will help or resolve the issue with a professional?
The purpose of this, I am unable to grasp, appearing before the police officer for what?
As a witness when he is called for.
So as a witness, of course, as a witness he is called for, because please understand the role of the police. His role is to find out the fact, collect evidence. He has to present before the jurisdictional magistrate or the trial court. So in that endeavor, he would be calling people, the witnesses, would be recording the statements, would be getting the documentary evidence if available, and he presents it to the court with his report. Ultimately, it is the judge who has to take the decision. That is there. So whoever comes with good faith, of course, they are not usually troubled. But in other than things which I have pointed out there, in normal cases, it doesn't happen.
Okay. One more question to you, sir, before going to Shri Ahluwalia ji. One more question. Normally, it is also seen that you go to a particular police station and appear before either at that time sub-inspector may be there, or a police inspector may be traveling, and he has been asked to sit from morning till afternoon till the police inspector comes. Supposing it happens on numerous occasions, say 1 time, 2 times, 3 times, whether any option is there for that particular person to take to the next level, or what is the option left to the professional?
It is always there. That's why there is hierarchy. If at police station level things are not happening, if he feels that he is being troubled or harassed, of course, next his senior officer is there. The inspectors are there as circle inspectors as far as districts are concerned. As far as the commissioner rates, inspector is the in charge of police stations here. Then here, the aggrieved person can approach the assistant commissioner of police or the deputy commissioner of police in PT, or he may meet the commissioner also. He can apprise of his difficulties whenever he went to police station. He was made to sit from morning till evening. All those things he can learn. And police at senior level, they view it very seriously. And definitely they will take appropriate action to correct the behavior of the subordinate officer. That only thing, those things have to be brought to the knowledge of the senior officer. So their doors are always open. Mostly senior officers are very responsive in that way. But at the lower level, some sort of lethargy may be there, some sort of delay may happen every time. But there is always an opportunity to be the senior officer. That is the right thing to do. That can be done.
Okay, thank you so much.
At the end of my speech, I wanted to tell, if you feel something is not happening or not going in the right way, not as per law, then you have every opportunity to meet the senior officers. That's what I wanted to tell at the end of my speech, but I forgot. Anyway, through your question, I'm answering them.
Thank you so much. Sir, to Ahluwalia ji, normally you will find company secretaries in practice, they are being appointed as directors in foreign subsidiary companies. So when they are appointed as a director in foreign subsidiary companies, they also sign various returns, documents. So sometimes it may so happen that there may be also in litigations which may happen outside India as well as in India. So in that case, if it is an outside India, what kind of role responsibility the company secretary as a director should take in case of foreign companies?
See, again, it depends from case to case. When you say that there is some litigation which has taken place outside, the litigation is against the company. It is not against the director.
Yes.
And the director is only representing as one of the representatives of the company. So, as far as India is concerned, there is no vicarious liability in criminal law. But as far as civil law is concerned, the entire company is liable, and he is liable as one of the directors of the company. So I don't think there is a problem. As long as there is a foreign company, necessary information has been conveyed to the income tax and the statutory authorities, then there should be no problem.
Okay. Sir, now with ongoing everything happening online, and whether there is any possibility recording of statement being done online?
Well, this is something which is a subject matter of discussion. Rightfully speaking, there are a few impediments, but actually it can be done. There is nothing which can not be done. In fact, I would say that one of the biggest takeaways of this corona pandemic has been that, virtual courts can actually play a very, very predominant role going ahead. Now imagine, I mean, people sitting in the comfort of their home, even the clients, they can watch court proceedings. So the next thing is going to be recording of the evidence, and there is something to that effect which is being formulated, I think, at the level of the Supreme Court, where they are considering as to how to go ahead with this.
Okay.
One additional point I would like to make, that whenever a company secretary was to appear before the court, before the police station, like one of the questions was that, they are made to sit from morning till evening and said, kal aana, right? So this kind of a thing, which is a very normal thing, it can be genuine, it can be as a means of harassment, but every time they go, they should always try to get their presence endorsed in the register. At times, again, see, I'll be talking more about the negatives because these are things which one is facing as a practitioner. At times, they don't allow you to enter it in the register. Then subsequently, before the court, they say he never came. And then we say, no, we came for 5 days, so then they'll present the register. So one thing is that the moment you go there to the police station, whether it is CBI, whether it is police, kindly just walk up to that place, show the notice and get your entry registered.
Okay. Sir, one question has come saying that if someone is charged by Sf5 or ED and get acquitted by the lower courts, how far these agencies can go? Of course, normally you will find that it can go up to Supreme Court level. However, whether there is any ruling or any this question is to Makhija ji. How far can the agencies can go?
Okay, see, the point is, first, you'll have to understand that what are the facts of the case, what are the issues involved, and whether these are similar charges or not. The double jeopardy will come into play only when these things are there. The cause of action should be similar, and the offense which has been committed is also similar. But the fact of the matter is that SFIO works under the provisions of the Companies Act. Like supposing a CBI is working, they will not be bothered about the Companies Act. They will be more bothered about their IPC. So they will invoke most of the IPC sections. So as far as the SFIO is concerned, they will be looking at the Companies Act. So these two becomes two different, maybe on the same issue, but the inquiries are obviously on a different platform which are there.
Thank you so much, sir. There are few more questions which are there. However, due to paucity of time, I need to conclude the webinar which has been organized by the Institute of Company Secretaries of India. Before I finally conclude, let me thank Shri T.G. Krishna Bhatta. Let me thank Shri Diljit Singh Aluwalia. Let me thank Ashish Makhija ji. In spite of your busy schedule, you have still made it to this particular program. I am sure that the inquiry with regards to the proceedings which have been conducted, our members would have honed their skill. While deliberating, there were many points which were brought about with regards to the inquiry department by whether it is CRPC, whether it is Evidence Act, and the most important arm so far as all the professional is concerned is the good faith. And in case if the professional can show that the act which has been committed by somebody, but you were a part of it, for example, like the resolutions, you may not be physically present, but you are acting based, you are signing a document based on certain documents which are available, based on certain certifications, like the documents what were quoted, Aadhaar, PAN, and many other documents. And if we are done in good faith, we are sure that there will be leniency which will be exercised, and you will find we can come out automatically so far as the information is concerned. While I belong to the state of Karnataka, you will find Ahluwalia ji spoke about FIR. There is a provision made in the state of Karnataka where even in kiosk you can go and you can make and information can be filed with any, you need not have to go to the police station, but you can even in various malls you will find a kiosk has been put in wherein you can file your first information report, your details of complaint can be written on the particular kiosk, and you will find immediately actions are being taken. Aluwala ji excellently spoke about what are the effectiveness as a professional we need to take. whether it is a strategy, whether it is institutional censors, whether it is delegation of responsibility, whether it is legal prophylactic cover, which is required to be taken as a preventive measure, excellently narrated, and the various case laws what he cited. Sir, thank you very much for your lucid presentation. Ashish Mohija ji also spoke about excellent thing, knowledge, integrity, ethics, professional independence, ethical behavior, and the safety net what you spoke about. Above all, we as a professional and especially company secretary, you will find that the motto of our institute is Satyam Vada, Dharmam Chara. I am sure, speak the truth, abide by the law. Most of our members, or let me say one step ahead, all our members follow in letter and spirit the motto of our institute, Satyam Vada and the Dharmam Chara. The webinar which is being organized today and the discourse which has taken place and the various words of wisdom which is shared by Shri Krishna Bhatta as well as Shri Aluwalia ji as well as Makhija ji, I am sure that it will go a long way for the purpose of regulating our professional, and I am sure our professionals both in employment and practice are going to gain with the webinar which has been hosted. I also wish to thank our secretariat led by Ashish Mohanji and especially the department, Shri Madam Alka Arora ji, for organizing this particular program as well as the IT department team for all the help and assistance which has been provided. I also would like to thank all those our members who have joined for this particular program, and I am sure that they have been enriched by the knowledge what has been shared by all the three learned professionals. I am sure that all our members would be making the best use of the professional expertise what they have gained by virtue of this discourse. Thank you once again, and we look forward for many more programs, webinars for the interest of our members as well as for the students. Thank you once again, Shri T.J. Krishna Bhatta ji, Shri Dirjit Singh Aluwalia ji, as well as Ashish Makhija ji for coming in spite of your hectic schedule. Thank you very much. Thank you.